Greetings dear viewers, Supreme Court Justice Clarence Thomas stated Monday that pro-affirmative motion arguments being made earlier than the courtroom reminded him of pro-segregation arguments. What is the background? The Supreme Court heard oral arguments for students for fair admissions in the University of North Carolina on Monday. As we get into details of this video, please take a minute of your precious time to hit the subscribe button and notification bell for latest updates from us. Of course, the value of the instances can't be overstated. First, the courtroom will determine whether or not race can play a function in university admissions, which is presently criminal and is recognized as affirmative action. Second, the courtroom will decide whether Harvard College is violating Title V of the Civil Rights Act by means of penalizing Asian American applicants, attractive in racial balancing, overemphasizing race, and rejecting plausible race-neutral alternatives, in accordance to Skatusblog, and whether or not a college can reject a race-neutral choice due to the fact it would trade the composition of the pupil body, besides proving that the choice would motivate a dramatic sacrifice in tutorial fantastic or the instructional advantages of general student body diversity. During oral arguments, Thomas requested North Carolina Solicitor General Ryan Park for a definition of diversity and to provide an explanation for the educational benefits of diversity. Mr. Park, I've heard the phrase diversity pretty a few times, and I do not have a clue what it means, Thomas noted. It looks to imply the whole thing for everyone. I'd like you to supply us a particular definition of diversity, he asked. Park, however, ought to now not supply a precise definition of diversity. First, we outline variety the way this courtroom has in this court's precedents, which potential a largely various set of standards that extends to all exclusive backgrounds and views and no longer completely restrained to race, he responded. Regarding the academic advantages of diversity, Park claimed there is no dispute whether or not range is really useful in education. When pushed further, he pointed to research about inventory buying and selling that declare racially various corporations of human beings making buying and selling selections operate at a greater level. The mechanism there is that it reduces groupthink and human beings have longer and greater sustained disagreement, and that leads to an extra environment-friendly outcome, Park claimed. Thomas fired back, well, I wager I don't put lots inventory in that, due to the fact I've heard comparable arguments in desire of segregation too. Thomas's objection to affirmative motion is nicely known. In a preceding case Grutter v. Bollinger, the case that ought to be overturned, Thomas defined how the racial issues innate in affirmative motion are dehumanizing. The Constitution abhors classifications primarily based on race no longer solely due to the fact these classifications can damage preferred races or are based totally on illegitimate motives, however additionally, due to the fact each and every time the authorities locations residents on racial registers and makes race applicable to the provision of burdens or benefits, it demeans us all, he wrote in an opinion. In every other affirmative motion case, Fisher v. University of Texas, Thomas explicated his contrast to arguments for segregation. It is beside the point below the 14th Amendment whether segregated or combined faculties produce higher leaders, he wrote. Indeed, no courtroom nowadays would be given the recommendation that segregation is permissible due to the fact traditionally black faculties produced Booker T. Washington, Thurgood Marshall, Martin Luther King Jr., and different distinguished leaders, he explained. Likewise, the university's racial discrimination can't be justified on the floor that it will produce higher leaders. What is honest view on this video? Drop your comments below and thanks for watching.